Chapter 1, Introduction to the Paralegal Career. Welcome to the world of paralegalism! This chapter introduces you to the exciting and dynamic field of paralegal studies, launching your career. As a paralegal, you'll play a vital role in the legal system, working alongside attorneys and other legal professionals to support clients in cases. Let's explore the opportunities and responsibilities that come with this rewarding career. Job titles and definitions. Paralegal, a professional who assists attorneys with various tasks, such as research, document preparation, and case management. A legal assistant, similar to a paralegal but may have more administrative responsibilities. Law clerk, a student or recent graduate working in a law firm or court, often assisting with research and drafting documents. The scope of your legal career. Paralegals work in various settings, including law firms, private and public, corporations, government agencies, nonprofit organizations, courts, ladders in large law offices. Large law firms often have a hierarchical structure with opportunities for advancement. Junior paralegal, senior paralegal, lead paralegal, paralegal manager, supervisor or team lead. Major players. American Bar Association, ABA, National Association of Legal Assistants, NALA, American Association for Paralegal Education, AAPE. Paralegal salaries. Salaries vary depending on location, experience, and industry. According to the Bureau of Labor Statistics, median annual salaries for paralegals and legal assistants range from $40,000 to over $80,000. Factors influencing the growth of paralegalism. Increased demand for cost-effective legal services. Growing need for specialized knowledge and skills. Changes in technology and law practice management. Oh, you're studying law? Clarifying the difference between paralegal studies and law school. Paralegal programs focus on practical skills and knowledge. Law school prepares students to become attorneys. Your online reputation. As a paralegal, you'll represent clients and law firms online, maintain a professional digital presence, create a LinkedIn profile, be mindful of social media activity. Conclusion. This chapter introduced you to the paralegal career, exploring job titles, definitions, and the scope of the field. As you continue your studies, you'll gain a deeper understanding of the skills and knowledge required to succeed as a paralegal. Reflection questions. 1. What aspects of paralegalism interest you most? 2. How do you think technology is changing the paralegal profession? 3. What are your goals for your paralegal career? Let's discuss chapter objectives. After completing this chapter, you should be able to understand the extent of legal disputes in the country, know the major classifications of paralegal titles, identify the major employers of paralegals and career ladders for paralegals. Describe the importance of precision in the practice of law. Know the definition of a paralegal. Identify the factors that determine a paralegal's salary. List the major organizations in paralegalism and the roles they play. Understand the factors that have contributed to the development and growth of paralegalism, including the impact of Missouri v. Jenkins. Let's break down these objectives and explore each one in more detail. 1. Extent of legal disputes. The United States has a complex and litigious society, with millions of legal disputes arising each year. Paralegals play a crucial role in supporting attorneys and clients navigating these disputes. 2. Paralegal titles and classifications. Common paralegal titles include paralegal, legal assistant, law clerk, litigation paralegal, corporate paralegal. To major employers and career ladders, paralegals work. Law firms, private and public. Corporations, government agencies, nonprofit organizations, courts. Career ladders may include junior paralegal, senior paralegal, lead paralegal, paralegal manager, supervisor or team lead. 4. Precision in the practice of law. Precision is critical in legal work as small errors can have significant consequences. Paralegals must be detail-oriented and meticulous in their work. 5. Definition of a paralegal. A paralegal is a professional who assists attorneys with various tasks, such as research, document preparation, and case management. 6. Factors determining paralegal salary. Salaries vary depending on location, experience, industry, education, and certifications. 7. Major organizations in paralegalism. American Bar Association, ABA, National Association of Legal Assistants, NALA, American Association for Paralegal Education, AAPE. These organizations provide resources, training, and support for paralegals. 8. Factors contributing to the growth of paralegalism. Increased demand for cost-effective legal services. Growing need for specialized knowledge and skills. Changes in technology and law practice management. Missouri v. Jenkins, 1989. a landmark Supreme Court case that recognized paralegals as part of the market rate for legal services, contributing to the growth of paralegalism. Now that we've covered the chapter objectives, let's move on to the next topic. Reflection questions. 1. How do you think the paralegal profession will evolve in the next 5-10 years? 2. What skills do you think are essential for a paralegal to succeed in the field? 3. How do you plan to stay current with changes in the legal industry and paralegalism? Let's discuss. Launching your career, welcome to the field. You probably fall into one or more of the following categories. You have never worked in a law office. A, you are or once were employed in a law office and now want to upgrade your skills. You want to explore the variety of careers in law for which a paralegal education can be a point of entry. As you begin your legal education, you may have a large number of questions. What is a paralegal? Where do paralegals work? What are the functions of a paralegal? How do I obtain a job? How do attorneys and paralegals work together as a team? What is the difference between a paralegal and the clerical staff of a law office? How do new paralegals adjust to the realities of a law practice? How is the paralegal field regulated? Who regulates and for what purposes? What are the ethical guidelines that govern paralegal conduct? And what career options are available once a paralegal has obtained experience? It is an exciting time to be working in the law. So many aspects of our everyday lives have legal dimensions. The law plays a dominant role in a spectrum of issues that range from the status of the unborn to the termination of life support systems. More than 107 million cases are filed every year in state and federal courts. One study concludes that 52% of Americans have a legal problem. 1 out of 3 will need an attorney's advice in the next 12 months. In a large survey of U.S. corporations, 87% reported that one or more lawsuits were commenced against them in the past 12 months. The news media are preoccupied with laws that have been broken, laws that no longer make sense, and laws that ought to be passed to create a more just society. Caught up in the whirlwind of these debates is the attorney and the attorney's team, a prominent member of which is the paralegal. A prominent paralegal was once asked why she became a paralegal. Deep down, she said, a good number of us entered the profession because legal proceedings touch everyone on a very personal basis several times during a lifetime, so it is a profession that everyone can relate to. As a paralegal, you also gain the satisfaction of knowing you are able to help solve a problem for a client 3A. There are other satisfactions as well. Once you have completed your paralegal education and gained experience on the job, you can explore a variety of career options within traditional paralegal employment settings. In addition, say an experienced corporate paralegal in a law firm might leave the firm to take a higher paying position as a securities analyst for a corporation. An experienced estates paralegal at a law firm might leave for a more lucrative position as a trust administrator at a bank. An extensive list of these law-related jobs is given in Exhibit 224 at the end of Chapter 2. Perhaps the most dramatic example of a paralegal position serving as a stepping stone to other jobs is the large number of former paralegals who have used their legal training and experience to run for political office, particularly at the city and county levels of government. Peggy Marino, for example, used her paralegal background to help her win a seat on the Board of Education in New Jersey. Peggy now serves on the financial and negotiations committees of that board. She credits her paralegal experience as having prepared her for those roles. Similarly, when paralegal Deborah Bowe was appointed to the Minnesota Board of Medical Practice, she said that she has read enough legal documents to know how to read between the lines and make my way through the issues that will come before the board. Representative Mary Squires of the Georgia legislature feels the same way. She was a paralegal before she ran for office. Because of a paralegal's preparation and organization skills, she felt equipped for the rigorous life of a legislator. After serving in the House, Mary was elected to the state Senate and is currently a candidate for state insurance commissioner. Of course, not all experienced paralegals go into politics, but the experience of these paralegals demonstrates the value and versatility of legal education. Do you know what time it is? Perhaps you're wondering what working in the law will be like. One of the hallmarks of legal work is its diversity. In 5 years, if you meet a classmate and compare notes on what your workdays are like as paralegals, you'll see similarities, but you will probably be startled by the differences. One way to gauge what working in a law office might be like is to answer a particular question. Stop what you are doing for a moment and answer this question. Do you know what time it is? Depending on when you are reading this book, you will probably look at your watch or the clock on your cell phone and answer 9:45 and 1:30 RM, 3:32 RM, 11:28 RM, etc. There could be hundreds of possible answers. But if you answered in this manner, you've made your first mistake in the study and practice of law. Look at the question again. Read it slowly. You were not asked, what time is it? You were asked, do you know what time it is? There are only two possible answers to this question, yes or no. Welcome to the law. One of the singular characteristics of the field you are about to enter is its precision and attention to detail. Vast amounts of time can be wasted by answering the wrong question. In fact, attorneys will tell you that one of the most important skills in the law is the ability to identify and focus on the question, the issue that must be resolved. Developing this sensitivity begins with the skill of listening very carefully. It also involves thinking before responding, noting distinctions, noting what is said and what is not said, being aware of differences in emphasis, and being aware that slight differences in the facts can lead to dramatically different conclusions. Even relatively minor variations in punctuation can sometimes have legal consequences. Compare, for example, the following two statements and note the dramatic difference in meaning that results from the placement of commas. Johnson said the officer hid the evidence. Johnson said the officer hid the evidence. In 2008, Chief Justice of the United States John Roberts administered the presidential oath of office by having Barack Obama solemnly swear that I will execute the office of President of the United States faithfully, but the Constitution states that the adverb faithfully should go before the verb that it modifies. Solemnly swear that I will faithfully execute the office of President of the United States. After the inauguration ceremony, the Chief Justice returned and administered the oath again, this time by the book. The hallmark of a professional is precision in language and the ability to identify what is different or unique about a particular person or situation. In this sense, highly competent paralegals are true professionals. Another major characteristic of law is its focus on definitions and intentions. Attorneys are preoccupied with questions such as what definition did the legislature intend and what does that clause mean? For example, if a will says I give $30,000 to my three children, Bill, Grace, and Sam, does each child receive $30,000, or is this amount to be split among the three children so that each receives $10,000? The answer depends on the intent of the deceased when the will was written. On September 11, 2001, when two airplanes struck the two towers of the World Trade Center 16 minutes apart, was the landlord of the towers entitled to one insurance payment of $35 billion or two payments totaling $7 billion? The answer turned on the definition of the word occurrence in the insurance contracts. Was there one attack, one occurrence, or two? After extensive litigation, the landlord was not successful in convincing the courts that there were two occurrences under all of the insurance contracts involved in the case. Another dramatic example of controversy generated by a definition occurred during a famous grand jury hearing that was videotaped and later played on national television. The witness giving testimony under oath was a graduate of Yale Law School and a former constitutional law professor. In testimony that captivated the nation, he said that his answer to a particular question involving sexual relations with an intern would depend on what the definition of is in the question. The attorney giving this testimony was President Bill Clinton. In a recent discussion on LinkedIn, the social network for professionals, paralegals were asked about the career they have chosen. Here are some of the responses. And I'm constantly intellectually stimulated and have made amazing friends. I've been with the same firm for 17 years. Longer than any of my romantic relationships, and still have days when my heart beats faster and I am excited about something I am doing, usually digging up hard-to-find information, helping a client get much-needed benefits, learning new technology, or writing substantive content. Each day brings something new. If you let it be known that you are looking for a challenge, you will certainly find it in this career field. Not every case in a law office makes the headlines, and not every paralegal is satisfied with all aspects of his or her job. Yet, the potential is there for a paralegal career to provide substantial fulfillment and a broad range of opportunities. In short, you have a great deal ahead of you in the study of law. It's going to be a fascinating adventure. The scope of your legal education. Legal education is a very broad area of study. You will be covering a great deal of material in your courses. Will you use all of this material on the job? Not necessarily, yet the material must be covered to comprehend the legal system and the world of attorneys. For example, you will learning about appellate briefs and sophisticated legal research, even though many paralegals never draft such briefs nor perform such research. Yet you need to have a basic understanding of such tasks in order to communicate with attorneys and to perform assignments related to these tasks. In short, understanding the role of a paralegal requires an understanding of and exposure to a wide range of paralegal and attorney skills as you begin the journey of comprehending the practice of law and the legal system as a whole. Areas that are essential to the performance of specific paralegal tasks include and the functions of courts, legislatures, and administrative agencies, and the rules of professional responsibility ethics governing attorneys and paralegals. The rules of grammar and clear communication. The ability to state facts accurately and comprehensively. And the basics of computer hardware and software on your desk and in the cloud. And the ability to adapt to the different standards of different attorneys in an environment where time pressures can be intense. Without a grasp of these essentials, a paralegal career can flounder. Hence, we will spend a good deal of time on them. Yet we will also cover the big picture, which includes tasks that many attorneys never assign paralegals to perform. This broader perspective is needed to develop into a well-rounded paralegal and to be ready for the great diversity that awaits you within the legal community. Major players. During this course, we will meet many organizations. Here is an overview of some of the major players, not necessarily listed in order of influence. A National Federation of Paralegal Associations, NFPA, National Association of Legal Assistants, NALA, NALS, the Association for Legal Professionals, NALS, American Bar Association Standing Committee on Paralegals, SCUP, your State Bar Association, see Appendix B, your local paralegal association, see Appendix B. These organizations are covered in some detail throughout the remaining chapters of the book, but a brief word about each will be helpful at this point. All 6 organizations extensively promote and most offer continuing legal education, CLE, which is training in the law, usually short-term, that a person receives after completing his or her formal legal training or after becoming employed. Continuing legal education, or CLE, is defined as training in the law, usually short-term, that a person receives after completing his or her formal legal training or after becoming employed. Certification is defined as the process by which a non-governmental organization grants recognition to a person who has met the qualifications set by that organization. National Federation of Paralegal Associations, NFPA, www Paralegal.org. The NFPA is an association of more than 50 state and local paralegal associations throughout the country. Individual paralegals can also be members, but most are connected to NFPA through their local paralegal association. More than 10,000 paralegals are part of the NFPA network. NFPA offers voluntary certification for entry-level paralegals, PCCE, the Paralegal Core Competency Exam. By entry level, we mean that the certification credential can be earned without having paralegal job experience. In the job market, entry level also refers to a starting position for someone with little or no experience. NFPA has another voluntary certification program for paralegals with experience, PACE, the Paralegal Advanced Competency Exam. We discuss these credentials in Chapter 4. National Association of Legal Assistants, NALA, www.nala.org. NALA is primarily an association of individual paralegals, although 81 state and local paralegal associations are affiliated with NALA. See Appendix B. More than 18,000 paralegals in the country are represented by NALA. It offers voluntary certification for entry-level paralegals, CLA, Certified Legal Assistant, Certified Paralegal, and for paralegals with experience, APC, Advanced Paralegal Certification. NALS, the Association for Legal Professionals, WWN.org. The oldest national association in the country is NALS, the Association for Legal Professionals. The association consists of more than 4,000 paralegals and legal secretaries in 100-plus chapters throughout the country. NALS offers a voluntary certification examination, PP, Professional Paralegal. See Chapter 4. The National Association of Legal Assistants, NALA, was initially formed as a breakaway association from NALS. Both associations are still headquartered in Tulsa, Oklahoma. At one time, NAL stood for National Association of Legal Secretaries. The organization kept the abbreviation but changed its meaning. See Exhibit 1.1 concerning the convention activity of NFPA, NALA, and NALS. American Bar Association Standing Committee on Paralegals, SCOP, www.americanbar.org, Groups Paralegals, HTML. The American Bar Association, ABA, is a voluntary association of attorneys. No attorney must be a member, yet it is a powerful organization because of its resources, its prestige, and the large number of attorneys who have joined. The ABA has a standing committee on paralegals, SCOP, that has had a significant impact on the growth of the field. The role of the ABA has included the publication of research on paralegals, the establishment of a voluntary program of approving paralegal schools, and the creation of an associate membership category for paralegals. State Bar Association of your state. Most state bar associations have been active regarding the role of paralegals in the practice of law. Many of the associations have issued 1, guidelines on the proper use of paralegals by attorneys, and 2, ethical opinions that apply the state's ethics code to an attorney's use of paralegals. We examine such guidelines and opinions in Chapter 5 and in Appendix D. Some state bar associations have followed the lead of the ABA and allow paralegals to become associate or affiliate members. Your local paralegal association. Paralegal associations fall into at least 14 categories, some of which overlap. 1 nationwide, e.g. NFPA NALA/NALS. 2 statewide, e.g. Illinois Paralegal Association. 3 region-wide, encompassing more than one state, e.g. Rocky Mountain Paralegal Association. 4 region-wide within a state, e.g. South Florida Paralegal Association. 5 county-wide, e.g. Santa Clara County Paralegal Association. 6 city-wide, e.g. New York City Paralegal Association. 7 practice-specific, e.g. Houston Corporate Paralegal Association. 8 division of a bar association, e.g. Paralegal Division of the State Bar of Texas. 9 association of associations, e.g. Empire State Alliance of Paralegal Associations. 10 school-wide, each Fresno City College Paralegal Association. 11 manager-focused, e.g. International Practice Management Association. 12 association whose membership is limited to paralegals, e.g. Orange County Paralegal Association. 13 association whose membership consists of paralegals, legal secretaries, and other non-attorneys, e.g. NALs. 14 foreign Canadian Paralegal Association. Most paralegals in the country have joined a state, regional, county, city, or bar-affiliated paralegal association. Through CLE and networking, a great many paralegals have found major career support and inspiration through active participation in their local paralegal association. If any of them have a student membership rate, you should consider joining now while you are in this course. Job titles, paralegal, and legal assistant. For convenience, this book uses the title paralegal. At one time, another common title was legal assistant. For years, most people agreed that these titles were synonymous, just as the titles attorney and lawyer are. Yet the titles paralegal and legal assistant have been the source of confusion and debate. For example, in some state governments, a legal assistant positions are attorney positions. In the federal government, most legal secretaries are called legal assistants. More significantly, many private law offices have changed the title of their legal secretaries to legal assistants without changing the requirements for their position or the duties they perform. Those who favor this title change say it reflects the broader roles many secretaries play. Cynics, however, argue that the change is because courts can give attorneys separate fees for the work of their legal assistants, but not for that of their secretaries. We will be examining such fees later in this chapter. The shift in title from secretary to legal assistant has not been universal. There are still individuals called legal secretaries in offices throughout the country. Yet the number of legal secretaries now called legal assistants is substantial, and this has led many to conclude that the legal assistant and paralegal titles are no longer synonymous. There is an emerging preference for the paralegal title. For example, many local associations have voted to change their name from the Legal Assistant Association to the Paralegal Association. One of the largest paralegal organizations in the country, the Legal Assistant Division of the State Bar of Texas, changed its name to the Paralegal Division of the State Bar of Texas. As indicated, an important committee of the American Bar Association is the Standing Committee on Paralegals. Its former name was the Standing Committee on Legal Assistants. The National Association of Legal Assistants, NALA, however, is adamant that the terms legal assistant and paralegal are used interchangeably. This is also the view of the International Practice Management Association, IPMA. Yet even IPMA has gone through a name change. It was once known as the Legal Assistant Management Association. NALA itself has acknowledged this trend. As we will see in Chapter 4, if you take and pass NALA's certification exam, you have a choice of being called a Certified Legal Assistant, CLA, or a Certified Paralegal, CP. The former title has been available since the 1970s. The latter was added as an option in 2004 and is now preferred by those who pass the exam. Some laws, discussed in Chapter 4, indeed treat paralegals and legal assistants as synonyms. Yet, the momentum continues on many fronts to separate the positions of legal assistant and paralegal and to prefer the latter. To summarize, and at one time, everyone considered paralegal and legal assistant to be interchangeable titles. They were synonymous. Paralegal became the preferred title after many attorneys allowed their secretaries to be called legal assistants. Some laws and some organizations, however, still maintain that the titles are interchangeable. Other titles. This is not to say that paralegal and legal assistant are the only titles in the field. Far from it. Many other titles are in use. Several reasons account for this diversity. First, there are no national standards regulating the paralegal field. Every state is free to regulate or to refuse to regulate a particular occupation. Second, most states have not imposed the kind of regulation on paralegals that would lead to greater consistency in titles within a particular state. For example, most states have not imposed minimum educational requirements or licensing. Hence, few restrictions exist on who can call themselves paralegals, legal assistants, or related titles. Although there are some major exceptions in states such as California, Florida, South Dakota, and Maine that limit who can use specific titles, for the most part, there are no such restrictions. To begin sorting through the maze, we examine two broad categories of workers: those who are employees of attorneys and those who are independent contractors. In general, independent contractors are self-employed persons who operate their own business and contract to do work for others. In general, those who hire the services of independent contractors do not control many of the administrative details of how the services are performed. The objectives or end products of the services, however, are controlled by those who hire them. We will be examining two kinds of independent contractors in the legal field: those who sell their services to attorneys and those who sell their services to the public without attorney supervision, a larger and more controversial group. Within these two categories, you will find considerable diversity in the titles that are used. Before examining independent contractors, let's first look at traditional paralegals, those who are employees of attorneys. Employees of attorneys. The vast majority, over 95%, are employees of attorneys. They may be called paralegal, the most common, legal analyst, legal assistant, legal paraprofessional, paralegal, legal assistant, legal service assistant, paralegal assistant, legal technician, attorney, assistant, mid-level, paralegal, lawyers, aid professional, legal assistant, lawyer's assistant. They are all traditional paralegals if they are employees of attorneys. Most are full-time employees. Some, however, are temporary employees who work part-time or who work full-time for a limited period when a law office needs temporary help, usually from paralegals with experience in a particular area of the law. If a law firm has a relatively large number of paralegals, it might call its entry-level people paralegal, entry-level paralegal, legal assistant, intake paralegal assistant, paralegal, junior paralegal, case clerk, legal assistant, clerk, case handler, paralegal, case handler, case technician, project case, assistant clerk/runner, paralegal clerk, docketing coordinator, project clerk, document clerk. Large law offices may also have individuals who help recruit, train, and supervise all paralegals in the office. This supervisor might be called paralegal manager, paralegal administrator, case manager, director of legal assistance services, director of legal assistance, director of paralegal services, director of practice support, legal assistant administrator, legal assistant coordinator, legal assistant supervisor, legal support, and professional personnel manager, manager of paralegal services, paralegal case manager, paralegal coordinator, paralegal supervisor, senior paralegal supervising, legal assistant manager. As indicated earlier, these individuals have their own association, the International Practice Management Association, IPMA. For more on entry-level and supervisory paralegals, see the discussion of career ladders later in this chapter. All of the titles listed thus far are generic in that they tell us little or nothing about the person's primary skills or area of the law in which he or she works. Other employee job titles are more specific: bankruptcy paralegal, commercial real estate paralegal, corporate law analyst, corporate paralegal, court researcher, paralegal, debt recovery, paralegal, demand specialist, docketing, paralegal, elder care, paralegal, family law, paralegal, foreclosure title, paralegal, government relations, paralegal, health advocate, healthcare, paralegal, international trade paralegal, legal advocate for day laborers, litigation, paralegal, litigation practice, support, specialist, patent prosecution, paralegal, personal injury, paralegal, probate specialist, public finance paralegal, real estate paralegal, senior medical paralegal, water law paralegal workers, compensation paralegal, tax paralegal. Other special categories include e-discovery paralegal, a person who helps an office identify information stored in digital formats, e.g., emails and spreadsheets, that may have to be exchanged between the parties during the discovery stage of litigation before trial. Depot summarizer, a person who summarizes pretrial testimony, particularly depositions, in which attorneys question potential witnesses outside the courtroom in preparation for trial. Compliance paralegal, a person who helps ensure that clients are complying with regulations that govern insurance, finance, construction, and other regulated industries. Judicial assistant, a person who works for judges within the federal, state, or local court system. Conflicts specialist, also called conflicts analyst or conflicts researcher, a person who helps the office determine whether it should refrain from taking a case because of a conflict of interest with present or prior clients. And the Chapter 5, nurse paralegal, a nurse who has become a paralegal, using his or her medical training to help personal injury, PI attorneys locate and decipher medical records and perform other litigation tasks. Nurse paralegals are usually employees of law offices. When they function through their own independent businesses, they are often called legal nurse consultants, LNCs, or, if certified, legal nurse consultant certified, LNCCs. See the American Association of Legal Nurse Consultants, WWWALN.org. Some law firms divide their paralegals into two broad categories, litigation and transactional. Litigation paralegals work on cases in litigation, particularly in the pretrial stages of litigation. A transactional paralegal assists attorneys with clients engaged in a large variety of transactions, such as entering into contracts, incorporating a business, closing a real estate sale, or planning an estate. A few large law firms have positions called specialist, analyst, or consultant. These are non-attorneys who have a high degree of expertise in a particular area, such as immigration, pensions, medicine, accounting, or environmental regulation. Skilled paralegals are sometimes promoted into these positions. Occasionally, when an office wants its paralegal to perform more than one job, hybrid titles are used. For example, an office might call an employee paralegal investigator, paralegal legal secretary, paralegal librarian, administrative assistant paralegal. In general, the smaller the law office, the more likely it is that an employee will be asked to play multiple roles, even if he or she does not have a hybrid title. For example, an employee of an office with one attorney, a sole practitioner, could be the paralegal, the bookkeeper, the librarian, the investigator, the secretary, and the receptionist. Perhaps the strangest and thankfully the rarest hybrid title you may see is attorney paralegal. A California law firm placed an ad in a Los Angeles legal newspaper looking for an individual to work under this title. What's going on? The legal job market fluctuates. Depending on the state of the economy, jobs for attorneys might be abundant or scarce. In lean times, parts of the country could be flooded with unemployed attorneys, many of whom are recent law school graduates. Occasionally, these attorneys apply for paralegal jobs. An article in the American Bar Association Journal, taking note of the plight of unemployed attorneys, was titled "Post-Law School Job Maybe as Paralegal." Some law firms are willing to hire a desperate attorney at a paralegal's salary because the firm can charge clients a higher billing rate for an attorney's time than for a paralegal's time. Most law firms, however, think it is unwise to hire an attorney for a paralegal's position. The two fields are separate employment categories. Firms know that the attorneys are not interested in careers as paralegals. Yet there will continue to be attorneys available for paralegal positions and law firms willing to hire them, particularly when the firms need temporary legal help. There is a small category of attorneys who frequently seek work as paralegals. An attorney who has been disbarred or suspended from the practice of law may try to continue working in a law office by taking a job as a paralegal until he or she can reapply for full admission. Such work is highly controversial because of the temptation to go beyond paralegal work and continue to practice law. Consequently, some states forbid disbarred or suspended attorneys from working as paralegals. In most states, however, it is allowed with restrictions. Key terms: networking, establishing contacts and sharing information with people, A, who might become personal or professional resources for you, and B, for whom you might become a personal or professional resource. A traditional paralegal is a paralegal who is an employee of an attorney. Independent contractors: a self-employed person who operates his or her own business and contract to perform tasks for others. In general, the latter do not control many of the administrative details of how the work is performed. Transactional paralegal: one who provides paralegal services for an attorney who represents clients in transactions such as entering contracts, incorporating a business, closing a real estate sale, or planning an estate. A paralegal who does not work in litigation. Sole practitioner: an attorney who practices alone. There are no partners or associates in the office. Independent paralegal, OI, an independent contractor who sells his or her paralegal services to and works under the supervision of one or more attorneys. 2. An independent contractor who sells his or her paralegal services directly to the public without attorney supervision, also called a freelance paralegal, legal technician. In some states, however, the paralegal and legal assistant titles are limited to those who work under attorney supervision. Document Service Provider, DSP: 1. A non-attorney who works without attorney supervision to provide legal document assistance to individuals who are representing themselves. 2. Someone who helps another prepare or process documents. Self-employed individuals who sell their services to attorneys. Independent contractors who sell their services to attorneys perform many different kinds of tasks. For example, they might draft an estate tax return for a probate attorney or digest, i.e., summarize pretrial documents for a litigation attorney. Most independents work out of a home office. Some do their work in the law offices of the attorneys for whom they work. See Exhibit 2.2 in Chapter 2 for the internet site of an independent paralegal in Appendix G on setting up an independent business. Independents who operate entirely online, as opposed to going to the offices of attorneys who hire them, are called virtual assistants or virtual paralegals. An independent might work primarily for one law office, although most work for different offices around town. Even though independent contractors are not employees, the attorneys who use their services are still obligated to supervise what they do. In Chapter 5, we will study the ethical problem of supervising a non-employee. In addition, we will cover the conflict of interest danger that can exist when an independent contractor works for more than one attorney. There is no uniform title that these self-employed individuals use. Here are some examples. Independent paralegal, the most common, contract paralegal, freelance paralegal, legal technician, self-employed individuals serving the public. Finally, we examine those independent contractors who sell their services directly to the public. As a group, they are known as document service providers, DSPs, and non-attorneys, who work without attorney supervision to provide legal document assistance to individuals who are representing themselves. DSPs do not work for attorneys. They may have special authorization to provide limited services, as when a statute allows them to assist clients in Social Security cases. To find out what titles they use in your area, check the yellow pages under entries such as paralegal, legal, divorce, and bankruptcy. Examples of DSP titles include bankruptcy petition preparer, BPP, legal document preparer, LDP, independent paralegal, paralegal, legal document assistant, LDA. In Chapter 4, we will cover an exciting development in the field of independent contractors who sell their services directly to the public without attorney supervision. The creation of the Limited License Legal Technician, LLLT, in Washington state. Many other states are considering similar positions. Controversy over DSPs has come from three main sources: some of their clients, some bar associations, and some traditional paralegals. And a few disgruntled clients of DSPs have filed complaints against them that have resulted in state prosecution for the unauthorized practice of law, UPL. The organized bar has instigated similar UPL charges on the ground that the public needs protection from DSPs, particularly those who lack formal training. The bar also complains that the public might be confused into thinking that anyone called paralegal or who uses the word legal in their title works for an attorney. An unstated reason for opposition from the bar is the unwelcome competition that DSPs give to some practicing attorneys. A significant number of traditional paralegals resent the use of the paralegal title by some DSPs who work directly for the public. Most traditional paralegals have been through a rigorous training program and are subject to close attorney supervision on the job. These traditional paralegals resent anyone being able to use the paralegal title without similar training and supervision. Unauthorized practice of law, UPL, using or attempting to use legal skills to help resolve a specific person's legal problem when the assistance is provided by someone who does not have a license to practice law, and when the assistance requires such a license or other authorization. 2. A non-attorney's performance of tasks in a law office without adequate attorney supervision when those tasks are part of the practice of law. 3. Delegating tasks to a non-attorney that only an attorney can perform. Paralegal, a person who performs substantive legal tasks on behalf of others when those tasks are supervised by an attorney who would be required to perform the tasks if the office did not have a paralegal. 2. A person with legal skills who works under the supervision of an attorney or who is otherwise authorized to use those skills. This person performs tasks that do not require all the skills of an attorney and that most secretaries are not trained to perform. In most states, the formidable opposition from these three sources has not put DSPs out of business. In fact, their numbers are growing. Although most states allow them to call themselves paralegals, a few states have imposed title restrictions. In California, for example, DSPs cannot call themselves paralegals or legal assistants unless they work under attorney supervision. If a California attorney is not responsible for their work, they must call themselves legal document assistants, LDAs. If they provide landlord-tenant help, they must be called unlawful detainer assistants, UDAs. In Arizona, DSPs who help persons with legal documents are called certified legal document preparers, CLDPs. At the federal level, even greater restrictions have been placed on individuals who provide bankruptcy assistance. In every state, they must be called bankruptcy petition preparers, BPPs. Later, in chapters 4 and 5, we will more closely examine the controversy generated by DSPs, including proposals in some states to increase their role. The definition of a paralegal we will use in this book is a person who performs substantive legal tasks on behalf of others, when those tasks are supervised by an attorney who would be required to perform the tasks if the office did not have a paralegal. Definitions have been written by state legislatures and state courts, state bar associations, local bar associations, American Bar Association, American Association for Paralegal Education, the Paralegal Associations. To find out if your state has adopted a definition, check Appendix D. By far the most important definitions are those written by state legislatures and courts. Not every state has a definition written by its legislature or by its courts, but the number of states that have them is steadily growing. Here's an example of a definition enacted by the state legislature in Illinois. The definition is typical of the definitions used in many states. Paralegal means a person who is qualified through education, training, or work experience and is employed by a lawyer, law office, governmental agency, or other entity to work under the direction of an attorney in a capacity that involves the performance of substantive legal work that usually requires a sufficient knowledge of legal concepts and would be performed by the attorney in the absence of the paralegal. Such definitions are often interpreted to include independent contractors who sell their services to attorneys but are not employees of the attorneys. Many bar associations, paralegal associations, and the Maine Paralegal Educators Association have adopted definitions that are similar in scope to the Illinois definition. The language of the American Bar Association's definition has been widely adopted, with or without modification, by the other associations. See Exhibit 1 to 2. Three major characteristics are common to most definitions of a paralegal. A paralegal has acquired legal skills through education, training, or on-the-job experience, works under attorney supervision, performs substantive legal work that the attorney would have to perform if the office did not have a paralegal. Under the first characteristic, there are two ways that individuals acquire legal skills. One, formal education or training programs, and two, on-the-job training, OT. When the paralegal first came into existence, see discussion of history later in this chapter, most paralegals acquired their skills through OT. Today, most do so by completing formal programs. Under the second characteristic, paralegals work under attorney supervision. This covers the vast majority of paralegals in the country, including independent contractors who sell their services to and are supervised by attorneys but are not attorney employees. What about independent contractors who sell their services directly to the public without attorney supervision? As we have seen, some states, e.g. California, restrict the paralegal title to persons who work under attorney supervision. The definition of a paralegal in such states would not include independent contractors who sell their services to the public without attorney supervision. This conclusion, however, is not universal. In many states, independent contractors can call themselves paralegals even if they do not work under attorney supervision. Under the third characteristic, the two key themes are 1, the absence test, and 2, substantive legal work. We need to take a close look at each of these themes because they will be relevant to the question of whether attorneys can receive paralegal fees for the tasks performed by their paralegals. The third characteristic states the absence test. Under this test, a task is a paralegal task if it must be performed by an attorney if the office does not have a paralegal. If a task is a paralegal task, it is not a clerical or secretarial task. 3 conditions must be met for a task to be classified as a paralegal task under the absence test. Most secretaries do not have the skills to perform the task. Most paralegals have the skills to perform the task. An attorney would have to perform the task if the office did not have a paralegal but did have a secretary. To demonstrate, examine the following 2 tasks. Task number 1, drafting, writing a complaint. If the office did not have a paralegal, would an attorney have to perform this task? Yes. A complaint is the plaintiff's first court filing, pleading, that states a legal theory for suing, called a cause of action. Legal skills are required to draft even relatively uncomplicated complaints. In general, most experienced paralegals have the skills needed to draft such complaints, but most secretaries do not have such skills. Consequently, if the office did not have a paralegal, the attorney would have to draft the complaint. Therefore, this is a paralegal task. Task number 2, typing a complaint. If the office did not have a paralegal, would an attorney have to perform this task? No. A secretary could type the complaint. Using a typewriter or word processor does not require legal skills. If the office had a secretary, an attorney would not have to type the complaint. The secretary could type it. Therefore, typing a complaint is a clerical or secretarial task, not a paralegal task. The absence test requires you to examine who could perform a task, not who actually performs it in a particular office. Attorneys who type their own complaints are still performing a clerical task. The question is whether the attorney would have to perform the task if the office had a secretary, but not a paralegal. Similarly, there are some veteran secretaries who are able to draft complaints. This does not mean that such secretaries are performing clerical tasks when they draft complaints. The task is a paralegal task, even if there are some secretaries who can perform it. The absence test requires you to focus on the skills of most secretaries and most paralegals. What is substantive legal work, SLW? There are two ways of answering this question. First, we can simply apply the absence test. If an attorney has to perform a task because the office has no paralegals, then the task is SLW. In other words, SLW is non-clerical work. Second, we can list specific tasks and say that all tasks like those on the list constitute SLW. In Delaware, for example, a court said that SLW includes but is not limited to such activities as A. Factual investigation, including locating and interviewing witnesses. B. Assistance with depositions, interrogations, and document production. C. Compilation of statistical and financial data. D. Checking legal citations. E. Correspondence with clients, opposing counsel, and courts. From preparing, reviewing, and answering petitions and other pleadings to gum. Similarly, note the specificity in the following list from the State Bar of Texas. Substantive legal work includes, but is not limited to, the following: conducting client interviews and maintaining general contact with the client. B. Locating and interviewing witnesses. C. Conducting investigations and statistical and documentary research. Drafting documents, correspondence, and pleadings. Summarizing depositions, interrogatories, and testimony. F. Attending executions of wills, real estate closings, depositions, court or administrative hearings, and trials with an attorney. Substantive legal work does not include clerical or administrative work. Fees, the amount charged for services rendered. Paralegal fees, a fee that an attorney can collect for the non-clerical work of the attorney's paralegal. The fee covers the paralegal's substantive legal work on behalf of the client. Contingent fee, a fee that is paid only if the case is successfully resolved by litigation or settlement, regardless of the number of hours spent on the case. The fee is also referred to as a contingency. A defense contingent fee, also called a negative contingency, is a fee for the defendant's attorney that is dependent on the outcome of the case. Court cost charges or fees paid to and imposed by the court that are directly related to litigation in that court. Example, court filing fees. Special expenses. Special expenses are charges incurred by a law office that are unique to the representation of a particular client. An example is the cost of a hotel and travel when an attorney must conduct a trial in another city. Operating expenses. Operating expenses are charges incurred by the office in order to stay open and provide services to any and all clients. Examples include rent, insurance, and secretaries. Another name for operating expenses is overhead. Paralegals are not part of a firm's overhead. They are a source of income for the firm through paralegal fees, which can be substantial. Most clients pay the first three categories: attorney and paralegal fees, court costs, if any, and special expenses, if any. With limited exceptions, they do not pay for overhead. Clients do not receive a separate bill for their share of the electricity the office used while representing them. The law office is expected to pay for such overhead out of the fees it receives from all its clients. It is possible, however, for a client to agree to pay a separate fee for some secretarial help if the amount charged is reasonable. When the attorney-client relationship is formed, the attorney and client enter a fee agreement that specifies what fees and other payments will be the responsibility of the client. The agreement is called an attorney-client fee agreement. See an example in Exhibit 8.1 in Chapter 8, or an engagement letter. There are two sources of attorney and paralegal fees. The main source is the attorney's own clients, which is the norm, called the American rule, in the United States. Unless the case is taken on contingency, the client pays these fees whether or not the attorney wins the case. Some other countries follow the English rule, under which an opponent pays the fees of the winning side in litigation. Although we do not follow the English rule, there are three situations in which the losing side does pay the attorney and paralegal fees of the winning side. In these limited situations, we follow a version of the English rule. Paying the other side's fees is called fee shifting, which we will now examine. Fee shifting. The three situations in which fee shifting occurs in the United States are triggered by prior agreement, bad faith, and special statutes. A prior agreement. Parties can always agree to shift payment of fees and related costs. In a separation agreement, for example, the wealthier spouse might agree to pay the fees and costs of the other spouse. In many states, the divorce court has the power to order such a shift, even if the parties have not agreed to do so on their own. Also, in many consumer contracts, the parties might agree to a clause stating that the buyer of goods or services must pay the fees and costs of the seller if the seller sues the buyer for non-payment. Bad faith. Bad faith is dishonesty or abuse in one's purpose or conduct. Suppose, for example, that a court is convinced that a party has filed a frivolous motion solely to harass the opponent. The court in such a case might require the party making the frivolous motion to pay the fees and costs of the opponent who is forced to respond to the motion. Special statute. Congress and some state legislatures have passed special fee-shifting statutes to encourage aggrieved parties to bring litigation in certain areas of law. The purpose of such statutes is to support specific social or policy goals in areas such as civil rights, environmental protection, employment discrimination, antitrust conduct, and securities fraud. Under these statutes, attorney and paralegal fees and costs are paid by the defendant if the plaintiff is successful in the litigation. The cases in which such fee shifting can occur are called statutory fee cases. Without fee shifting, injured parties might not be able to bear the cost of seeking a remedy in the courts. Hence, violations of civil rights, environmental laws, and the like would not be remedied. This is not good for society as a whole. Fee shifting statutes, therefore, have been passed to encourage aggrieved parties to challenge such violations in court. In the first two categories of fee shifting cases, prior agreement and bad faith, fees can be awarded regardless of who wins the case. In statutory fee cases, however, a party can be ordered to pay the fees of its opponent only if the opponent wins the case. In statutory fee cases, not all legislatures and courts use the same language in describing the relationship between attorney fees and paralegal fees. Sometimes paralegal fees are referred to as being part of attorney fees. At other times, attorney fees and paralegal fees are treated as separate entities. Regardless of how the relationship is phrased, the result is the same. A court can award two sets of fees, one for attorney work and another for paralegal work. Overhead, the operating expenses of a business, e.g. office rent, utilities, insurance, and clerical staff, for which customers or clients are not charged a separate fee. It should be noted, however, that some attorneys charge clients for clerical or secretarial time, which can be ethical if the client agrees. The amount charged is reasonable, see Chapter 5. An engagement letter is a letter that identifies the scope of services to be provided by a professional and the payments to be made for such services. American rule: each party pays his or her own attorney's fees regardless of who wins the case. In English rule, the losing side in litigation must pay the winner's attorney fees, also called loser pays. Fee shifting requires one party to pay another party's attorney fees and paralegal fees because of prior agreement, bad faith, or special statute. Bad faith, dishonesty, or abuse in one's purpose or conduct, frivolous, lacking merit. On a legal position that cannot be supported by a good faith argument based on existing law or on the need for a change in existing law, aggrieved, injured, or wronged, and thereby entitled to a remedy. Statutory fee cases, a case applying a special statute that gives a judge authority to order the losing party to pay the winning party's attorney fees, including paralegal fees, and costs. Remedy: I. The means by which a right is enforced or the violation of a right is prevented, compensated for, or otherwise redressed. 2. To correct. The plural is remedies. Market rates in statutory fee cases. When fees can be shifted in a statutory fee case, how are fees calculated? For attorney fees, courts use a lodestar under which the number of hours reasonably spent on the case is multiplied by the prevailing hourly rate in the community, called the market rate, for similar work by attorneys. Other factors might also be considered above the lodestar in setting the fee, such as the quality of representation, delay in receiving payment, and risk at the outset of the litigation that the attorney will receive no fee. Before 1989, there was substantial doubt about how paralegal fees would be calculated in statutory fee cases. Would the market rate for paralegal fees be used similar to how attorney fees are calculated? Assume that an attorney wins a statutory fee case. The attorney requests and receives attorney fees based on the market hourly rate in the area for attorneys working on this kind of case. The attorney also submits a request for paralegal fees for the time the paralegal spent on the winning case. How does the court determine the amount of paralegal fees to award? Two possibilities exist, only one of which uses the market rate. Prevailing hourly market rate for paralegals. The market rate is the amount, on average, that law firms in the community charge their own clients for paralegal time, e.g. $110 per hour. Actual cost to the law firm. Actual cost is the amount that a law firm must pay to keep its paralegal, e.g., $50 per hour to cover the paralegal's salary, fringe benefits, office space, and other overhead costs related to maintaining any employee. Of course, the winning side in a statutory fee case will argue that it should receive the market rate for paralegal time, and the losing side will want an actual cost standard. In 1989, the U.S. Supreme Court, in the landmark case of Missouri v. Jenkins, resolved the issue in favor of using market rates. The Jenkins holding does not apply to every statutory fee case, but its influence has been so substantial that the predominant rule today is to use market rates for calculating paralegal fees. The Jenkins case involved a Missouri desegregation suit under FOUR 1988 of the Civil Rights Attorneys' Fees Awards Act. This was a federal statute of Congress that allowed fee shifting in civil rights cases. The lower court awarded the winning party $40 an hour for paralegal time, which was the market rate for paralegals in the 1980s in the Kansas City area. On appeal, the losing party argued that it should pay no more than $15 an hour, which at that time was the actual cost to the law firm of having a paralegal in the office. In addition to paralegal fees, the case covered the award of fees for law clerks who are students still in law school or are law school graduates who have not yet passed the bar. Like paralegals, law clerks are non-attorneys. For convenience, the court refers to paralegals and law clerks collectively as paralegals. As you can see from the opinion, the Supreme Court rejected an actual cost standard for paralegals under the fee-shifting statute the court was applying. A footnote in the opinion refers to an amicus curiae brief filed by the National Association of Legal Assistants, NALA. This is a friend of the court appellate brief submitted by a non-party that obtains court permission to file the brief with its views on how the case should be resolved. Keep in mind that Missouri v. Jenkins is a federal case involving one federal statute, the Civil Rights Attorneys' Fees Awards Act. The following categories of cases are not required to adopt the conclusion of Fenkin. Federal cases interpreting other federal statutes. State cases interpreting state statutes. For example, a state court applying a state fee-shifting statute could decide to calculate paralegal fees at actual cost rather than at the prevailing market rate. Nevertheless, Missouri v. Jenkins has been persuasive. The vast majority of federal and state courts have adopted its reasoning for allowing paralegal fees at market rates in statutory fee cases. This is why Missouri v. Jenkins is a landmark case. The Jenkins holding was reinforced in 2008 when the Supreme Court held in Richland Security Service Company v. Chertoff that paralegal fees were recoverable at market rates under a different federal fee-shifting statute, the Equal Access to Justice Act. Challenges to awards of fees in statutory fee cases. Parties who lose statutory fee cases are often understandably upset when they are faced with losing a judgment and paying the attorney fees and paralegal fees of their opponent. A corporation, for example, might lose an antitrust judgment that requires it to pay its opponent $20 million in damages plus millions more to cover the time spent on the case by the attorneys and paralegals of its opponent. Although the losing side will probably lose the argument that seeks an actual cost calculation of paralegal fees, it may still be able to argue that there are errors in the winning side's request for fees. Let's look at the steps a party takes to request fees and some of the arguments that challenge the request. Challenging fee requests in a statutory fee case. And at the conclusion of the trial, the winning side submits to the trial judge a petition that requests attorney and paralegal fees. The petition lists the tasks performed by the attorney and the time taken to perform these tasks. The number of hours is divided by the market rate attorneys charge in the area. The result is the total amount requested for attorney fees. The petition also lists the tasks performed by a paralegal and the time taken to perform these tasks. The number of hours is divided by the market rate of paralegals in the area. The result is the total amount requested for paralegal fees. The losing side can then present challenges to the fee petition. Here are 3 challenges that will be successful. Some of the tasks performed by the attorney should have been delegated to a paralegal. The attorney should not receive an attorney rate for performing a paralegal task. Some of the tasks performed by the paralegal should have been delegated to a secretary. Paralegal fees in statutory fee cases are limited to substantive legal work, SLW. Paralegal fees cannot be awarded for clerical tasks performed by a paralegal. Some of the tasks performed by the attorney should have been delegated to a secretary. No fees should be awarded for clerical tasks performed by the attorney. There is nothing improper or unethical about an attorney performing a paralegal task or a clerical task, nor is there anything improper or unethical about a paralegal performing a clerical task. In a busy office that is faced with deadlines or that is shorthanded, everyone must pitch in to do what is needed to respond to immediate client needs. In this environment, you will seldom hear someone say, "That's not my job." However, when the time comes for a request for fees in a statutory fee case, care must be taken to avoid requesting attorney fees for paralegal or clerical tasks, and to avoid requesting paralegal fees for clerical tasks. Suppose, for example, that an attorney performs the following tasks in a statutory fee case. Questions a witness at a deposition, 4 hours. Reads the transcript of the deposition of this witness and highlights each time the witness mentions any health ailment, 2 hours. Negotiates a settlement with opposing counsel, 10 hours. The attorney has spent 16 hours performing these tasks. Assuming the attorney wins the case, a requirement for fee shifting, can he or she obtain 16 hours of attorney fees? No. The 2 hours spent looking for health quotes in the transcript is a paralegal task. The request for attorney fees must be limited to the 14 hours spent questioning the witness and negotiating the settlement. For an attorney to seek attorney fees for performing paralegal tasks would be the equivalent of Michelangelo charging Sistine Chapel rates for painting a farmer's barn. See the footnote in the Missouri v. Jenkins case in which the court reminded us that the dollar value of a task is not enhanced simply because an attorney performs it. Just as it is improper to seek paralegal fees for clerical tasks, it is also improper to seek attorney fees for paralegal tasks. A Delaware court phrased the concern this way: paralegal fees are not a part of the overall overhead of a law firm. Paralegal services are billed separately by attorneys, and these legal assistants have the potential to greatly decrease litigation expenses and, for that matter, greatly increase the efficiency of many attorneys. By permitting paralegal fees, the danger of charging these fees off as the attorney's work is hopefully extinguished. By the same token, the danger of charging off a secretary's services as those of a paralegal is very real and present. Record keeping. Timekeepers, attorneys, and paralegals must keep careful records of the tasks they perform and the amount of time spent on each task. Accurate timekeeping records of this kind will be used to help a court distinguish among attorney, paralegal, and clerical tasks. Again, it is not enough for an attorney to say that task X is an attorney task simply because an attorney performed it, or that task Y is a paralegal task simply because a paralegal performed it. The court will want to look at the nature of the task itself in order to determine who should have performed it. Fees will be awarded based on this determination. It is standard practice in most private law firms for timekeepers to keep detailed timesheets covering the entire workday. A paralegal's supervising attorney may need to enter these timesheets into evidence to justify the award of paralegal fees in statutory fee cases. Here is an example of what some courts require attorneys to demonstrate in their petition for paralegal fees. 1. The services performed by the paralegal must be legal in nature. 2. The performance of these services must be supervised by an attorney. 3. The qualifications of the paralegal performing the services must be specified in the request for fees in sufficient detail to demonstrate that the person is qualified by virtue of education, training, or work experience to perform substantive legal work, SLW. 4. The nature of the services performed must be specified in the request for fees to allow the reviewing court to determine that the services performed were legal rather than clerical. 5. As with attorney time, the amount of time expended by the paralegal must be set forth and must be reasonable. And 6. The amount charged must reflect reasonable community standards, the market rate for charges by paralegals. Summary of rules on fees. To summarize the rules on paralegal fees, let's look at A, all cases in which attorneys can charge their own clients paralegal fees, and B, special statutory fee cases in which the losing side can be ordered to pay the paralegal fees of the winning side. In all cases, 1. Attorneys can charge their own clients a separate fee for the work of their paralegals regardless of who wins the case. This is in addition to charging for the attorney's time. If the fee agreement says that the paralegal fee shall be for paralegal tasks, the firm should not charge for clerical tasks performed by the paralegal. 2. Timekeepers must keep detailed records, e.g., timesheets, on the tasks they perform and the time spent performing them. Contemporaneous record keeping is preferred over time records that are assembled long after the task is performed. 3. The amount of time a timekeeper takes to perform a task must be reasonable in light of the nature and complexity of the task. 4. The amount of the fee itself must be reasonable. In statutory fee cases, 1. The loser can be required to pay the attorney and paralegal fees of the winner. 2. The attorney will be required to demonstrate the paralegal's qualifications, e.g., education and experience, for the fees requested. 3. Attorney fees cannot be awarded when an attorney performs paralegal tasks. 4. Paralegal fees cannot be awarded when a paralegal performs clerical tasks. 5. The amount of the fee is based on the prevailing market rate that attorneys in the legal community charge their clients for paralegal tasks. This market rate rule applies if a court adopts the rationale of Missouri v. Jenkins, as most courts have. Career ladders in large law offices. There is no career ladder for paralegals working in a small law office that consists of one or several attorneys, a secretary, and a paralegal. In an office with more than 3 paralegals, career ladders are more likely to exist. When they exist, firms use a wide variety of titles. 2 examples used in law firms and 2 used in the law department of a large corporation. At the top of most career ladders where they exist is the paralegal coordinator or manager, with duties such as recruiting and screening candidates for paralegal positions, orienting new paralegals to office procedures, training paralegals to operate software used in the office, training paralegals to perform certain substantive tasks, such as digesting pretrial testimony, coordinating assignments of paralegals among the different attorneys in the office to help ensure that paralegals are given assignments they can perform and that they complete them on time. For more details on the role of the paralegal manager, as indicated earlier, paralegal managers have formed their own association, the International Practice Management Association, www.paralegalmanagement.org. Paralegal salaries, how much do paralegals make? Although some data are available to answer this question, there is no definitive answer because of the great variety of employment settings. Here are some relevant statistics. According to a 2015 survey by Robert Half Legal, a major legal staffing firm, the salary range for a case clerk assistant with 0 to 2 years of experience was $34,044.250 in law firms with 75 or more attorneys, $33,250.42.750 in law firms with between 35 and 75 attorneys, $31,038.500 in law firms with between 10 and 35 attorneys, $29,530.42.50 in law firms with between 1 and 10 attorneys, $33,750.47.250 in corporate law offices. The salary range for a mid-level paralegal legal assistant with 4 to 6 years of experience was $59,572.750 in law firms with 75 or more attorneys, $55,750.73,000 in law firms with between 35 and 75 attorneys, $51,250.64.250 in law firms with between 10 and 35 attorneys, $43,558.500 in law firms with between 1 and 10 attorneys, $57,550.74.750 in corporate law offices. According to the Bureau of Labor Statistics of the U.S. Department of Labor, the median salary of the 277,000 paralegals in the country was $46.90 2012. The median wage is the wage at which half the workers in an occupation earned more than the median amount and half earned less. The top 10% of paralegals earned more than $75,410. The bottom 10% of paralegals earned less than $29,720. According to a 2013 survey of the National Association of Legal Assistants, the national average salary of paralegals was $54,376, with an average annual bonus of $4,501, 38,867 1 to 5 years of experience, 51,484 6 10 years of experience, 54,347 11 to 15 years of experience, 58,952 16 to 20 years of experience, 60,075 21 25 years of experience, 64,002 more than 25 years of experience. According to a survey in Paralegal Today, the average paralegal salary in 2013 was $54,740. The highest paralegal salary in the survey was $118,500. The lowest paralegal salary in the survey was $24,960. The average paralegal salary in corporations was $63,064. The average paralegal salary in government was $59,402. Experienced paralegals do very well. If they have good resumes and have developed specialties that are in demand, they usually improve their financial picture significantly. Several other generalizations can be made about salaries across the country. Skilled paralegals and those with considerable responsibility earn high salaries. Paralegals who meet or exceed billable hour expectations tend to be rewarded with higher salary increases and bonuses. Paralegals who work in large private law firms tend to make more than those who work in smaller private law firms. Paralegals who work in large metropolitan areas over 1 million in population tend to make more than those who work in rural areas. Paralegals who work in legal aid or legal service offices that are funded by government grants and charitable contributions to serve the poor tend to make less than most other paralegals. Paralegals who work for attorneys who understand the value of paralegals tend to make more than those working for attorneys who have a poor or weak understanding of what paralegals can do. Paralegals who work in an office where there is a career ladder for paralegals, plus periodic evaluations and salary reviews, tend to make more than those who work in offices without these options. Paralegals who are career-oriented tend to make more than those less interested in a long-term commitment to paralegal work. In addition to the payment of bonuses, other fringe benefits are also relevant to the overall compensation picture, e.g., vacation time, health insurance, and parking facilities. Factors influencing the growth of paralegalism. In the late 1960s, most attorneys would have drawn a blank if you mentioned the words paralegal or legal assistant. According to Webster's Ninth New Collegiate Dictionary, the earliest recorded use of the word paralegal in English occurred in 1971. Today, the situation has changed radically. Most law offices either employ paralegals or are seriously considering doing so. A major exception is the one or two attorney office where the only staff member is a secretary who often performs paralegal tasks. Some surveys show that there is one paralegal for every 4 attorneys in law firms and one paralegal for every 2 attorneys in the law departments of corporations. It has been estimated that the number of paralegals may eventually exceed the number of attorneys in the practice of law. The U.S. Bureau of Labor Statistics says there are 277,000 paralegal jobs in the country. Between 2012 and 2022, employment will grow by 17%, faster than the average for all occupations. What has caused this dramatic change? The following factors have been instrumental in bringing paralegalism to its present state of prominence. 1. The pressure of economics. 2. The call for efficiency and delegation. 3. The promotion by bar associations. 4. The organization of paralegals. The pressure of economics. Perhaps the greatest incentive to employ paralegals has been arithmetic. Law firms simply add up what they earn without paralegals, add up what they could earn with paralegals, compare the two figures, and conclude that the employment of paralegals is profitable. There can be little doubt that the principal motivation prompting law firms to hire paralegals is the economic benefit enjoyed by the firm. The key to increased profits is leveraging. Leverage, often expressed as a ratio, is the ability to make a profit from the income-generating work of others. The higher the ratio of paralegals to partners in the firm, the more profit to the partners or owners of the firm, assuming everyone is generating income from billable time. The same is true for associates in the firm. The higher the ratio of associates to partners, the greater the profit to the partners or owners. In the best of all worlds, some of this increased profit will result in lower fees to the client. For example, Chief Justice Warren Burger felt that some attorneys charge excessive fees for tasks like closing real estate transactions. A greater part of that work can be handled by trained paralegals, and many law firms are doing just that to reduce costs for clients. If the state requires an attorney to do all the work at a closing, the law would have to be changed to allow paralegals to do what Berger suggests. We discussed such changes in Chapter 4. Exhibit 1 to 4 provides an example of the economic impact of using a paralegal. In the example, a client comes to a lawyer to form a corporation. We compare A, the economics of an attorney and secretary performing a task, assuming a fee of $2,500, and B, the economics of an attorney, secretary, and paralegal working on the same task, assuming a fee of $2,000. With a paralegal added to the team, the firm's profit is increased by 68% despite the lower client fee, and the attorney has 35 hours of billable time to spend elsewhere. Some studies claim an even higher profit increase due to the effective use of paralegals. The average billing rate attorneys charge clients for paralegal time is $92 per hour for paralegals with 1 to 5 years of experience, $116 per hour for paralegals with 6-10 years of experience, $130 per hour for paralegals with 26-30 years of experience. About 28% of paralegals with these rates are expected to produce a set number of billable hours weekly. Most work 40-hour weeks and are asked to bill at least 30 hours, called a billable hour quota or goal. Some law firms use the rule of 3 as a guideline to project profit from paralegal billing. Under this rule, total revenue should equal 3 times a paralegal's salary. Of this total, 1/3 goes to salary, 1/3 to overhead, and 1/3 to profit. When revenue from paralegal billing equals 3 times the salary, minimum profit expectations are met. For example, if a firm pays a paralegal $40,000 yearly and bills at $100 per hour, paralegal salary, $40,000, paralegal rate $100 per hour. The firm hopes to generate $120,000, which is $40,000 times 3. This summarizes the factors influencing the growth of paralegalism related to economics. Paralegal profitability example, forming a corporation. Let's compare the economics of using an attorney and secretary versus an attorney, secretary, and paralegal to form a corporation. Scenario A, attorney plus secretary. Fee, $2,500. Attorney time, 6 hours at $250 hour equals $1,500. Secretary time, 5 hours at 25 hour equals $125. Total cost, $1,225. Profit, $875. Scenario B, attorney plus secretary plus paralegal. Fee, $2,000. Attorney time, 25 hours at $250 hour equals $625. Paralegal time, 35 hours at $90 hour equals $315. Total cost, 1 through 65. Profit, $935. End comparison. Client saves, $500. Attorney profit increases 68%, $935 versus $875. Attorney gains 35 hours of billable time, $875 additional revenue. Using a paralegal benefits both the client, lower fee, and the attorney, higher profit and more billable time. Paralegal profitability simulation forming a corporation. Let's simulate the economics of using an attorney and secretary versus an attorney, secretary, and paralegal to form a corporation. Simulation inputs. Attorney hourly rate, $250 hour. Secretary hourly rate, $25 hour. Paralegal hourly rate, $90 hour. Client fee, attorney plus secretary, $20,500. Client fee, attorney plus secretary plus paralegal, $2,000. Task time, attorney wo paralegal 6 hours. Attorney wo paralegal 25 hours. Paralegal 35 hours. Secretary 5 hours. Run simulation. Costs, $1,625. Costs, $1,065. Results. Want to adjust inputs or run another scenario? Rule of 3 allocation. Job paralegal salary, $40,000. Overhead for this paralegal, $40,000. Profit to the firm, $40,027. Some firms use a rule of 3.5, under which gross revenue generated through paralegal billing should equal 3.5 times a paralegal's salary. Of course, the rule of 3 or 3.5 is not an absolute gauge for determining profit expectations from using paralegals. Other factors affect the profitability of paralegals for an office. A high turnover of paralegals in the office, for example, often means substantially increased overhead costs for recruiting and orienting new paralegals. One survey concluded that the annual attrition rate for paralegals is between 11 and 25%. Another factor that can offset the rule of 3 is the extent to which attorneys have more billable time because of a paralegal's performance of non-billable tasks. Some paralegals perform many tasks that cannot be billed to clients. Examples include recruiting new employees, helping to maintain the law library, organizing the office's closed case files, and doing some of the work on certain kinds of cases that an attorney would normally do for free, e.g., probating the estate of the attorney's brother-in-law. The more non-billable tasks, such as these, that a paralegal performs, the less time he or she will have available to devote to billable tasks. This, however, does not mean that the paralegal is a drain on profits. A non-billable task that a paralegal performs is often a task that the attorney, at least in part, does not have to perform. This, of course, enables the attorney to direct more of his or her efforts to fee-generating, i.e. billable matters. Directly related to a paralegal's profitability is his or her realization rate. A law firm does not always collect 100% of every bill it sends to its clients. Some clients simply refuse to pay, or they bargain down the bills initially sent to them. The realization rate is the percentage of the total amounts billed to clients that a law office actually collects. If, for example, the office fails to collect 10% of all the bills sent out during a given period, its realization rate is 90% for that period. Attorneys and paralegals have realization rates based on the percentage of the amounts billed from their hours that were actually collected. Of course, a paralegal has no control over whether the office is able to collect every billable hour submitted. Yet, many paralegals inquire about their current realization rate for their own information and possible use when discussing their value to the office, perhaps at annual review and bonus time. 2. The call for efficiency and delegation. Attorneys are overtrained for many of the tasks that they once had to perform in a traditional law firm. It eventually became clear that this was not the way to run an efficient office. The creation of the paralegal role was a major step toward reform. The results have been quite satisfactory, as evidenced by the following comments from attorneys who have hired paralegals. A competent paralegal for several years has been effectively doing 25% to 35% of the actual work that I had been doing for many years before that time. The results of our 3-attorney, 3-paralegal system have been excellent. Our office's efficiency has been improved, and our clients are receiving better service. It has been our experience that clients now ask for the paralegal. Client calls to the attorneys have been reduced by an estimated 75%. In light of such comments, it is surprising that the legal profession took so long to recognize the need to create the position of paralegal. The following historical perspective presents an overview of how attorneys came to this conclusion. 30. During the American colonial period, the general populace distrusted attorneys because many sided with King George III against the emerging independent nation. This is illustrated by the 1770 census report sent back to the king about a county in New Hampshire. Your Royal Majesty, Grafton County consists of 1,212 square miles. It contains 6,489 souls, most engaged in agriculture, but including 69 wheelwrights, 8 doctors, 29 blacksmiths, 87 preachers, and 90 students at a new college. There is not one lawyer, for which we take no personal credit, but thank an almighty and merciful God. Some colonies tolerated attorneys, but established roadblocks to their practice. In 1641, the Massachusetts Bay Colony prohibited freemen from hiring attorneys for a fee. Every man unfit to plead his own cause in court could employ a man, provided he gave no fee or reward for his pains. Furthermore, almost anyone could become an attorney without meeting rigorous admission requirements. States did not have training requirements to be an attorney until the 1940s. Before the 19th century, attorneys worked alone, with only occasional apprentices studying to be attorneys. The attorney basically operated independently, carrying his office in his hat. A personal attachment and devotion to detail were considered essential to becoming and operating as an attorney. In the early 19th century, George Wythe said about attorney education, "It is only by drudgery that the exactness, accuracy, and closeness of thought so necessary for a good lawyer are generated." Similarly, Abraham Lincoln emphasized this in his notes for a law lecture. If anyone claims exemption from drudgery, his case is a failure in advance. Attorneys were reluctant to delegate tasks to assistants because of this emphasis on personal effort and exactness. Attorneys also valued the personal relationship with clients highly. As late as 1875, Clarence Seward and partners avoided typewriters because clients would resent the impersonal nature of typed letters. However, the Industrial Revolution prompted changes in law practice, including specialization and growing concern for organization and efficiency. While many attorneys still carried offices in their hats, many, especially in the 1850s, shifted towards organized office management. Machines brought new employees such as typists, librarians, investigators, bookkeepers, office managers, accountants, and research assistants into large law offices. Initially, non-attorneys were hired primarily for clerical or administrative roles, but they soon took on more challenging responsibilities. In a Midwestern law office, a study noted, employees like head bookkeepers were given responsibility, such as recording meeting minutes, issuing proxy statements, and supervising tax filing. Attorneys increasingly delegated non-clerical duties to clerical staff, often in response to emergencies and new client demands. Staff development was often a result of on-the-job training during urgent situations, despite the haphazard manner of task delegation. By the 1960s, attorneys questioned whether a new type of employee, paralegals, should be created instead of expanding secretaries' roles. Several studies indicated that attorneys were receptive to this idea, concluding that many tasks could be delegated to paralegals. Today, this idea has become a dominant principle in law office management, with attorneys increasingly asking, why can't this be delegated? At present, no paralegals are full members of any bar association. In recent years, however, several state and local bar associations have invited paralegals to join their organizations in various capacities. The association might allow the paralegals in as associate or affiliate members of the entire association, including its committees and sections, associate or affiliate members of committees or sections only, or full members of special paralegal divisions. Bar associations have different requirements for paralegal membership. For example, an attorney attestation may be required, in which an attorney member of the bar confirms, attests, that the applicant performs substantive legal work, SLW, under attorney supervision. An example of an active paralegal unit of a bar association is the Paralegal Division of the State Bar of Texas, www.txp.org. It has more than 2,300 members. The annual voting membership fee is $70. In some of the bar associations, paralegals are allowed to vote on issues within the section, committee, or division of which they are members. Still, they cannot vote on general bar association issues. In 1982, the ABA Standing Committee on Paralegals proposed that the ABA create an associate category of membership for paralegals. The National Association of Legal Assistants, NALA, warmly endorsed the proposal, but the National Federation of Paralegal Associations, NFPA, opposed it, arguing that paralegal organizations should be autonomous and should not become part of a state or national association that regulates them. NFPA and others argued that the organized bar had a conflict of interest in regulating paralegals in light of the profit motive attorneys have in using paralegals. Today, however, this concern is rarely, if ever, raised. Paralegals take advantage of bar membership for a number of reasons. It looks good on a resume. It fosters a positive relationship between paralegals and attorneys. Employers often pay all or part of the paralegal's membership fee. Bar association meetings can be an excellent place for networking. Members receive paper or online newsletters and announcements, thus keeping them better informed about developments in the legal community. 4. The organization of paralegals. Paralegals have been organizing. There are approximately 200 paralegal organizations throughout the country, see Appendix B. This has greatly helped raise everyone's consciousness about the potential of paralegalism. We will be examining the work, impact, and value of these associations in the next several chapters. Oh, you're studying law. Can the landlord put my furniture out on the curb? What happens if I co-sign the note and it's not paid? Once your friends and relatives find out that you are studying law, you will probably start receiving legal questions such as these. Later in chapters 4 and 5, we will examine legal advice in some detail. You need to be very careful to avoid giving such advice. You do a poll ref or see a grin that seeks to dot how the LARFAC situations. Even if you know the answer, the proper response is, that's something an attorney would have to look into, or simply say, I don't know. Your online reputation. In today's computer-driven environment, the likelihood is strong that prospective employers will be seeking information about you on the internet. What will they find? Your online reputation is your brand, how you stand out, what makes you distinctive. As a professional, you will need an online presence, and it must be informative, intelligent, engaging, and conservative. In later chapters, we will cover ways to achieve such a presence through LinkedIn, Facebook, Twitter, and other social media sites. For now, the watchword is caution. On Google, Bing, or Yahoo, enter your name as a search term to find out what the internet currently has or says about you. On Google, Bing, or Yahoo, run this search: how to clean up your image on blank. In the blank, insert the name of any site you have joined. And if something exists about you on the internet that would not impress a prospective employer, follow the cleanup instructions of the site involved to try to remove it. Again, we will have more to say about building a positive online presence. In the meantime, find out what that presence is today and start learning how to remove and avoid anything negative. The law has a wide-ranging impact on our society. Large percentages of individuals and companies need legal assistance. Precision and attention to detail are critical attributes of anyone working in the law. Important organizations in paralegalism include the National Federation of Paralegal Associations, NFPA, National Association of Legal Assistants, NALA, NALS, the Association for Legal Professionals, the American Bar Association, ABA, your state bar association, your local paralegal association, and the American Association for Paralegal Education, AAFPE. The National Paralegal Associations offer certification and, along with the bar associations, promote continuing legal education. Although some laws and organizations assert that the titles paralegal and legal assistant are synonymous, the preferred title has become paralegal, as more and more legal secretaries are called legal assistants. Some states have laws that restrict the use of specific titles, but most states have no such restrictions. Paralegals are either employees of attorneys, traditional paralegals, or independent contractors who sell their services to attorneys, or who have authorization to sell limited services directly to the public without attorney supervision. Paralegals who have specialties include bankruptcy paralegals, corporate paralegals, family law paralegals, real estate paralegals, and e-discovery paralegals. In small offices, paralegals are likely to perform a variety of paralegal, bookkeeper, librarian, investigator, secretary, and receptionist tasks. Independent contractors who work without attorney supervision are document service providers, DSPs. They are sometimes charged with the unauthorized practice of law. They must call themselves bankruptcy petition preparers if they work in bankruptcy. In California, they must be called legal document assistants or unlawful detainer assistants. A few other states have similar restrictions and limit the use of the titles paralegal and legal assistant to those who work under attorney supervision. A paralegal is a person who performs substantive legal work, tasks on behalf of others when those tasks are supervised by an attorney who would be required to perform the tasks if the office did not have a paralegal. Definitions of a paralegal have been written by legislatures, courts, the American Bar Association, local bar associations, and paralegal associations. The three most common characteristics of the definitions are that the paralegal has acquired legal skills through education, training, or on-the-job experience, works under attorney supervision, and performs substantive, i.e. non-clerical legal work that the attorney would have to perform if the office did not have a paralegal. In most states, attorneys can charge their clients paralegal fees in addition to fees for attorney time. In statutory fee cases, the losing side in litigation can be forced to pay the attorney fees of the winning side. These fees can include separate fees for paralegal tasks. Under the landmark civil rights case of Missouri v. Jenkins, paralegal fees are determined by market rate. Paralegal fees in statutory fee cases are limited to substantive legal work performed by paralegals. Paralegal fees cannot be awarded in such cases for clerical tasks. Fee challenges in statutory fee cases can include claims that some of the tasks performed by the attorney for which fees are requested should have been delegated to a paralegal, and some of the tasks performed by the paralegal for which fees are requested were clerical. Paralegals must keep detailed and preferably contemporaneous records that specify the tasks they performed. Career ladders for paralegals exist mainly in law offices with more than 3 paralegals. Paralegal managers in large offices help recruit and train paralegals and coordinate their assignments. Paralegal salaries are influenced by several factors: experience, skills, level of responsibility, kind of employer, geographic area, meeting billable hour expectations, the employer's understanding of the paralegal's role, and the extent to which the paralegal is committed to the field as a career. One rough measure of paralegal profitability to a firm is the rule of 3. Under this guideline, gross revenue generated through paralegal billing should equal 3 times a paralegal's salary. Bar associations and paralegal associations have promoted the value of paralegals extensively. The economic impact they have had on the practice of law is the major reason the paralegal field has flourished and grown so rapidly. In a properly leveraged firm, paralegals can be a profit center without any sacrifice in the quality of the service delivered by the firm. Also, a paralegal can help attorneys redirect some of their energies from non-billable to billable tasks. As we will learn in subsequent chapters, there have been some dramatic developments in paralegalism in recent years, beginning in 2000, when California inaugurated a major program of paralegal regulation. This has prompted many other states to consider their own versions of regulation. Furthermore, the practice of law, legal education, and the legal profession are going through a period of re-examination. Change is clearly in the air. In a keynote address, Robert Stein, executive director of the American Bar Association, said that the 4 most important areas affecting the practice of law in the future were diversity, globalization, electronic contracts, and the growth of paralegalism. The paralegal profession, he said, is undergoing a remarkable transformation as the value of a well-trained paralegal is recognized by more and more law firms, corporations, and governments as a means of providing cost-effective services in an era of rising expenses and complex litigation. Echoing these themes, a recent study of the practice of law came to the following conclusions. The combined forces of globalization, technology, and market liberalization are creating new services, new delivery mechanisms, and new forms of competition. Those changes are altering client needs and expanding client expectations. Clients want services to be quicker, cheaper, and smarter. They want more transparency and involvement, and they want to be and stay connected. These are some of the themes we will be exploring as you now begin the journey of becoming a well-trained paralegal.